Okay, I think we've got our recording going. I know Tara is not going to be here, and we have lost a couple of people from the work group. Um, so all things considered, I don't know that we have anybody else who's going to be here today. So let's just go ahead and get started. Thank you, everybody, for contributing and getting in marked up versions. Actually, I think, does everybody here get one in? I feel like it was pretty close, right?
I sent comments, but not a specific.
Yeah,
Yeah,
which is totally fine. Sorry, go ahead.
Yeah, trying to see where there's commonality and area for discussion is very difficult.
We need multiple screens.
Yeah, touche.
I mean,
we need 5 screens. Jennifer, that's why I commented that Jennifer's input seemed to make sense, and I'm just curious for how to efficiently go through.
So I think most, if not all, of the bolded things, what I think, Dawn, you were talking about as the black letter, I think most, if not all of those should stay. Hold on, let me double check. Did I say put any of those in blue? Yeah. So my kind of thought piece is that there are some that feel more to me like best practices and less like hardline rules, specifically things having to do with communicating with a child in a developmentally and culturally appropriate manner. I don't know that we can require that of everyone right off the bat to be as soon as you start being dependency qualified, you have to be able to do that because there's some broader knowledge that I feel like we all want people to be able to do, but frankly, not everyone is, at least not at the beginning, able to do. And I have a hard time saying, the stuff that has to do with you need to know child development stages. That's fantastic. But I don't know how people are going to get trained on that until we have much more robust training options available. And for right now, I don't know that we can require that contractually. We're looking at this from what can we what are we going to be contractually seeing as contractual obligations? I don't know that we can require that. And that's just that's my viewpoint on how I was going through this. So
Kevin,
yeah.
That's a great way of thinking of it, contractually obligated. What is, given the diverse ways that we communicated our thoughts, what is going to be the best way to merge this into one document that we all can look at? I mean, I noticed you took a PDF and highlighted, which is what I did. Is there any way to get a Word copy of this and then one of us pull it up on the screen and one of us be in charge of making the edits as we communicate through looking at black letter, this, that?
I mean, I can do that, right? I can pull up a clean copy on my screen and make notes on it as we're going through. Let me download a fresh copy. Why is this not? Oh, that's why. Let's see.
Sorry, guys. I'm probably the problem child who just created a whole new document because that's the way that my brain worked.
and that is not a problem even a little, right?
It just, when you started getting all of those action and then other, it just gets so hard to wade through.
Yeah. Okay.
Maybe Kevin can be the edit master and each of us can look at our own mock-up. And as he goes through, we can weigh in, because I think am I hearing consensus that generally most of the black letter would become, what I refer to as the black letter, would become the contractually obligated standard, and then there might be some modifications.
Yeah. Okay.
Okay.
Got a fresh copy and I can go ahead and, oh, cool, that stayed. All right. I'm going to use the same color coding that I used for mine for us to all work together on, just because it'll be easier for me to turn this into a real draft. Okay, so if I'm not mistaken, does everyone agree that with some exceptions, the bolded black letter stuff is black letter, we're keeping that? Okay, I'm seeing a lot
I
of
mean,
nods.
for the
Go
most
ahead.
part, I think one example, we'll get to it, but like
Yeah.
page 12, the child client's lawyer should show respect and act professionally with the child client. I don't disagree with that, obviously, but isn't that kind of, I mean, do we have to say it? It's being a lawyer.
I actually approached that from a different standpoint. Okay, so let's go through those bolded pieces first, because those I think we're gonna be able to knock out real fast and easy, and then we'll get into the sub actions and commentary and look at what do we think is necessary, what's best practice, and what is what I would call surplusage, stuff that we don't actually need to say and put in there. Okay, so everybody is in agreement. 1A is black letter. Yeah.
Yeah.
All right.
Yeah. I mean, it's a
1B.
long way to say that, but yes.
1B.
Oh, let me get to it, because this is such a great treatise on how to be
I don't disagree, right?
Where did my B go? Okay.
It's
I'm
at the
good with
bottom of
B.
page 4. Yeah. Okay. Thumbs up. All right. I think I'm seeing consensus. I'll take this from a standpoint of, unless I hear otherwise, I will give people a few seconds. And if I don't hear anything, I'm assuming consensus. All right. C, when it's not reasonably possible to maintain a lawyer-client relationship, lawyer should conduct a thorough investigation. Consensus?
I had a footnote in C, so let me see what I wrote in my footnote. On the footnote, I wrote if I could get it to stay open, here we go. In the footnote for C, I wrote, add the following after the word lawyer. The child client's lawyer should consult with the experts and others that know the child to develop the objective facts and information. So I felt like that statement, if it were added to the black letter, would allow us to remove a lot of the commentary and action below it.
So that is one way to tackle it. I know that there is a discussion later, like either in the commentary or in one of the actions saying consult with experts about like matters of the representation. So whether we want to tackle it one way or another, let me put a note here that we'll come back to.
I'll just add a note that I thought what B says is said so many times elsewhere that like I didn't think it was important enough on its own. I guess it depends, because I'm talking about what is bolded directly after B to me is repeated like over and over and over again.
I put this in the wrong spot. That was for C, wasn't it? C was consult with, Dawn, was it B or C that you said consult with experts on?
It was C.
Okay.
After the add the following after that word lawyer. So there's a little pop-up that on mine that kind of explains it, but I just think
I just want to make sure that I put my note in the right place too. And then comment here. And so Dawn, if I understood kind of your take, most of it is get rid of most of the stuff that's not the black letter and just have it be a very, very bare bones document with reference it, like with somewhere to say, if you want more about this, look at the actual or at the
Yeah,
OSP
if you want
standards.
more, my thoughts are, if you want more about how to put these standards into action, go to the bar standards and the Oregon and make sure we have some standard that requires us to comply with the rules
Yeah.
of professional conduct, and then we don't have to have that extra language.
Okay, cool. We'll come up with that. We'll work on that structural component
Okay.
next. Okay. And then Kelsey, can you remind me?
Yeah, I just said, for me, like B, the information bolded after B,
Mhm.
and I guess to me, it's like that is inherent in A, right? Like
Oh,
we're to always be determining at what, you know, for a child with full decision-making capacity. And then because right, what comes after A that is bolded, and then the action that says, or Oregon Rules of Professional Conduct. So like we are already directed to determine any client's, capacity and be judging that over time. So to me, it was just like, well, I don't know if we need to explicitly state it or not.
how does the rest of the group feel on that?
Let me get back to one.
I look at it as A and B being different explanations of kind of the same concept, but A is your client does know how to give direction, and B is they can't. I like having them separate, so my vote would be for having them separate.
One of the things I think that's interesting about this is it in some ways posits that there's full capacity and
as if it's not a
diminished
spectrum.
yes. And
Yeah.
it's and what I think is important is sort of continually assessing where your child client is at. And so I do think it's important to remind people that they need to be assessing capacity, but like Kelsey, it is
Okay.
kind of the same process.
Well, my feedback would be, through the years, the most frustrating thing that I experience at conferences is how frequently people get bogged down in some kind of discussion about how to manage children clients. Like, when do they start to give, when is it client directed, on what level? And like so clearly people struggle with how to manage the ebbs and flows of that. And so I'm sort of leaning to leaving it in. I would want to look at, the ethics rules without the rules of professional conduct. I haven't memorized, but if they have a really explicit language about how to work with child clients or diminish or clients that aren't, when I think of clients in diminished capacity, I always think of the reality is most of our clients are not always getting some aspect of it.
Mhm.
And we rarely think like that in adult land, right? I mean, we're just like, okay, they're able to make their bad decisions, but in dependency land, we're back into it ebbs and we're like, are they really getting this or absorbing it or processing it effectively? I'm rambling, so I'm kind of neutral. I do think people really need, particularly newer lawyers, probably need as much guidance and direction. And if OPDC really wants to have that as a standard, saying it multiple ways could be helpful for people to understand their contractual obligation.
Jen.
I see where Kelsey's coming from with when you have a client, it is your job to make sure that you're, whether they're adult or not, what their capacity is for understanding. Like even with adult clients, no matter what genre of law you're practicing in, you need to make sure that they're understanding what you're asking of them when you're getting their position on what you're going to do legally. So I think to the extent that we're talking about diminished capacity on specific things versus diminished capacity entirely, that's something that you can have with every single client. And I think what and I think later on they're trying to get to is, I think it sounds to me when I read through this that when they talk about diminished capacity, what they mean is developmental capacity. At what point is your child client able to understand all of the things going on due to their age, not due to some brain injury or medical diagnosis or something that could happen to every single client that we have as an adult, but rather something that's very specific to child clients, which is the fact that their brain is still developing. So I think it makes sense to separate those two components of the, hey, this is a child, make sure that they're developmentally able to direct that kind of a position, that you're dealing with them in an age appropriate manner. I think that's the one that we all kind of laughed at earlier, which was, of course, it's going to be different for each kid and where they're developing and how they're developing. And it's going to be a nuanced evaluation. But that this first one of, hey, you need to check every client to make sure that they have the capacity to understand what you're telling them, makes sense. Sorry, I rambled there and lost my train of thought.
So, I mean, I feel like this is one of the more, this is one of the topics that is likely to have the most discussion around it, right? A lot of the other stuff is super discrete. It's very clear. This is the one that is kind of at the core of the philosophy of how to represent children, is what do you do about a kid who is somewhere along this line of decision-making capacity? I don't know that there's a wrong answer to this question. Or if there is, I think we're all very adept at getting away from it, right? This group isn't going to pick a wrong answer to this. So really, I think ultimately it just is going to come down to, and maybe this isn't low enough hanging fruit for us to really dive into right at the moment. So maybe we punt on the structural question for this and come back when we've got a little bit more we spent a little bit more time considering what each of the options are.
Yeah,
right?
I would agree.
Okay. So then let's keep going. C was the consult. Okay. All right. D. Child client's lawyer reasonably believes that there is diminished capacity and can't adequately act, may take reasonably necessary action. And then obviously there's a lot of specifics around this as to how you can do that ethically.
Did you move on to D?
Yes.
Okay. Can I just comment on C?
Sure.
So C says when it's not reasonably possible, blah, 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 the child client's lawyer should conduct a thorough investigation. And then the action says when the child client's incapable of directing the lawyer, the child client's lawyer must thoroughly investigate. So I'm just curious if OPDC, where they want to fall with those, if
That's a fantastic question, and I think it definitely gets at the heart of some of the split that we've got.
Yeah.
Personally, I go with must, right? And I will acknowledge that is not always something that I was able to do.
Yep.
So, but personally, I think the answer should be must. There are different ways we could word this. And
must conduct a reasonable investigation.
Yeah. Yeah. I mean, there's ways we can soften that side, but I think that the fact that you're doing an investigation at all has to happen, and then you can determine what the contours of that investigation look like. Good note, Kelsey.
You know, one of the things I was also thinking about with the action step for that
Mhm.
about the investigation is, to some extent, shouldn't we be doing some of that with all of our child clients, even if they can direct us?
Mhm.
Yeah, I don't disagree with you on that. So maybe this is less of a
Well, if it's go ahead. I'm
go ahead.
sorry, Kevin. I didn't mean to
No, no.
interrupt.
I was trying to like think as I was talking, and it was not happening. So go ahead.
Well, this goes towards, this standard is directed at what kind of relationship you have with a child and what to do, maintain a normal lawyer-client relationship. So with C where it talks about when it's not reasonably possible to maintain a normal lawyer-client relationship, I think they're talking about a different kind of investigation than investigating to help people make informed decisions. This type of investigation is designed to figure out how to achieve what you understand to be your client's goals and objectives. Because you're going to do that investigation to determine what course of action is most consistent with protecting the child client in the particular situation. But if you have a normal client relationship, you're going to do you're going to do what your client directs you to do, and you're going to do the investigation that focuses on achieving that goal or informing your client so they can help decide what their goal is.
Well, and then there's also the investigation that we would normally do for any client into what their family situation looks like, so we can have enough context of their life to give them that advice too. So there are multiple types of investigation, and I think I see what you're getting at here, which is this is the extreme, right? Like we had to narrow this focus real far because there is no way to get client direction. So in order for us to know what we need to do, thorough investigation. You need a more thorough investigation when your client can't tell you things. They can't direct you, so that you can get the sense of what would be the most protective, if I'm understanding you correct on.
Yes, well
Okay.
said.
Cool. Okay. So then do we leave this one? Because there are other directives in here on how to perform an investigation in other circumstances.
Well, I think I think you want to agree with Kelsey, and the language should be not that you should, but that you must do a thorough investigation and then determine what course of action. That you shouldn't determine your course of action without doing this investigation.
That is fair. All right. Let's no,
This is also almost word for word Rule 1.14, client with diminished capacity B. You cannot act in their own interest, but a lawyer must.
That's more permissive. I would say Rule 1.14B is far more permissive. And it's about taking the necessary protective action.
Okay, yeah,
for
you're
specific
right.
harms. Yeah. And that does come in, I think, with D. Yeah, I think you're looking more at what D is talking.
Oh, yes, I am. Sorry. I've moved on.
For any of those who have the chat up, I was typing through to try and organize my thoughts. But When it is not reasonably possible to maintain a normal lawyer-client relationship generally or with regard to a particular issue, the child client's lawyer must conduct a reasonable assessment of other objective facts and information from a variety of sources to determine what course of action is most consistent with protecting the child.
I'm
Does
gonna.
that
So my only concern with assessment, and this is like such wordsmithing, I think,
Yeah.
and you can
Love
tell
it.
me not to, but my concern about assessment is I feel like I know lawyers who will say, well, I assessed it in my head and not think of it as an investigation.
Right. And especially with how much of a before the 2017 before these standards were implemented, it was far more you know, it wasn't a I mean, I started practice just before these came out. So I don't know the history here. But my understanding is that it was much more culturally, it was much more part of the defense attorney culture to not be client directed, but instead be more of a best interests focus. But I don't have the history to be sure of that. I didn't practice at that time.
so?
And I know that is a common thing in other states. Oregon is not alone in being client directed, but it is not nationwide.
I do like the language that Jen just wrote. I'll just say it. Here, I'll thumbs up it or something.
Oh,
Okay.
the second one?
Yeah.
Agreed.
Okay.
Agreed.
Let me copy that one in then. Okay.
Well, and I think that there are weird ways that kind of the nationwide, the best interest approach seeps into, this is partly to Don's point about capacity, into other areas. I was at an ABA conference where somebody was talking about asking for a GAL for her mom client because she wasn't acting in her own best interest. And I was like, what?
Yeah.
Isn't that being an adult? I can go eat ice cream right now if I want to, and it will make me sick because I'm allergic, but I can do it.
I do have to keep telling my son he is more than welcome to start eating ice cream once he's old enough to appreciate that, yes, it will make him sick, and he's consciously choosing not to, that the benefit outweighs the cost, right? Otherwise, until then, we're keeping you here.
Yes.
Okay. All right. So do folk like this enough to say that's what we want? Like we could just replace C with that. I see a bunch of nods. I assume Jen is on board with it since Jen wrote it.
I
Okay.
try not to be that temperamental. Yes.
Okay.
Okay, cool. Then I will go through and I will make sure that we don't need to keep that up. All right, D. This one I don't think we can change much at all because that is basically 1.6 or 1.14. 1.14B. So, and I don't really have any interest in changing it. I think that is stated as it should be. All right. Let's see. E, child client's lawyer should not advise the court of the lawyer's determination of the child client's capacity. I think this goes to the don't undermine your own client's position thing. So I think this has got to stay. I'm getting a lot of head nods. Cool. All right. Relationship with the child client. Ensure a client is aware they have a lawyer and should communicate regularly and effectively. I feel like this is just like the central tenet of being a lawyer. So, all right.
Except it's really great when your kid clients come to court for their adoption ceremony and the judge says, and who's this? And they say, I don't know. And you're like, I just saw you at your house.
Kevin, my feedback was the highlighted portion of the first action item should become part of 2A black letter if OPDC wants to set a standard for contact.
Yeah, I that was gonna be like, that's gonna be part of mine. I do think
We're gonna have to have a conversation about that.
But it depends on how you look at first contact, and this is what we do with most of these standards. First contact is you're sending a letter, right? For most of these, first contact is sending a letter.
Did you say
And
send a letter to a child?
How
to
old
their
are we?
to their
A
foster, right?
We're
But
talking,
like, but
so few letters go out of my office.
Oh,
It's
and I'm
text
just
or-
basing off of what we did at UVPD when I was there, which is like you get assigned,
so
and
old
by the
school.
time you get back from court, there's something there for you to put your signature on.
Yeah, but shouldn't there be an actual rule about when you make contact with the kid you represent?
I think that comes in with well, so that's something we can craft, right? I do think that 24 hours is a exceedingly tight timeline to have actual like
Yeah.
contemporaneous contact. So
Yeah,
we're
Like
talking asynchronous, 24 hours is manageable and doable. If we're talking synchronous contact, then 72 hours is still a tight timeline in a lot of cases.
Yep.
Because coordinating with the placement, or I mean, even if they're placed in home, you still have to manage, and maybe you can do this at shelter and get your the parent attorney's permission to contact for setting up a meeting. Great, but there's a lot of scheduling stuff that goes into it, and 72 hours is, so what I had marked for this is that the first part, contact within 24 hours, assuming that we're talking asynchronous, that's a black letter. Contact within 72 hours, or like synchronous contact within 72 hours, that's best practice.
That's 3 days. Are you talking 3 business days? Are you talking 3 live human being days? Or, right? And is it face to face, or is it on the phone? Is it like,
I think synchronous.
well, you got
Yeah.
you got feasible in there. I'm totally
Yeah.
good with that. It's totally
Yeah, yeah.
reasonable.
Yeah. And like the standard, like further on down in the actions, it totally talks about, you want your first contact to be in person because that's how you develop the relationship the best. Again, though, that's an if feasible, because
So my comment is that if you're gonna say that the like contact, but it could be a letter, then that needs to be explained, because when I read this, it is you better get out and you better meet that client in person within 24 hours, or
Oh, see, I don't read it like that. I read it like a contact, and I read the,
well, what is contact with a child client, right? Like,
do you want a
do
definition?
they know you exist? Does that, like,
Do you text the client? Do you say, hi, my name's Dawn, you weren't in court, I met your family today, and I'm a lawyer. What do you call them on the phone? If you've got 4 prelims that you've got to cover because that's the system that your county might have set up, and you can't, do you have your assistant say, hey, we got a new text, email your assistant, we got a new child client, here's where they are. Can you make contact and let them know who we are, and set up an appointment? I interpret contact lawyer to equal lawyer's agent for contact. And then if it's like face to face later, it needs to be explained. And I think lawyers that are looking at their contract with the Office of Public Defense Services are going to do that. They're going to, unless there's a definition, they're going to be working their own definition. That's what lawyers do.
So my other concern with this is that when you've got a kid who's 8 months old, they quite frankly could care less what you do at all. Whether it's in a 24-hour time frame, a 72-hour time frame, a 72-month time frame. I mean, at that point, they're probably getting old enough to question things. But this rule needs to take into account that a lot of us are given information about a child client at, well, in Washington County, it's 11 a.m. You've got court at 1 p.m. or 1:30 p.m. And oftentimes they're still bouncing the child from one placement to another without a set time for it. So I do think that it has to be reasonable efforts. And I would argue that it should be a 72-hour business days to make sure that you can get a hold of that person, that you can, the resource parent, that you can work around school schedules or activity schedules, that you can actually get a straight answer from the caseworker about where your client is actually located and the contact information for that person. Does that make sense?
So, yes, again, though, I think what I'm hearing from you though, is to the second part, to the synchronous contact, not necessarily the initial like introduction. Because I anticipate like if you've got like a less than, I mean, heck, I'm trying to think when would a kid even like have a concept of what a letter is, right? Like, right? Like,
Especially now. Especially now.
At a certain point, like the contact within 24 hours can't mean like even just the letter being sent to the client. Okay, that's really at that point, the first contact is just kind of introducing not to the kid directly, but that's in part because contact with a child of too young of an age can't really be anything other than in person because they're just not going to have a concept. I mean, even a kid who, even if you tried to do a virtual visit, and this is why virtual visits for parents suck, at least in part, is like the kid may not have any idea of what the screen really means. They're not, the senses that they're using to affect contact aren't as much visual and auditory, it's other stuff.
And if we go really granular on that, I mean, consulting with your client in an age appropriate manner at the age of 8 months, you can't explain a lawyer to a client who's 8 months old. Like I have a hard time explaining what a lawyer is to a room with 3-year-olds and 4-year-olds. So,
no, and this is going to sound really weird, but even just like being there and letting them experience the fact that you're around them is still a form of contact, and they potentially become more, as they get older, they get a little bit more understanding of who you are and what role you play. But I don't know.
If the black letter law says within 24 hours, so we've got until 11 a.m. the next morning, I need to go out and try to see this 8-month-old in person. That feels unreasonable.
Could I recommend that we instead of think in terms of hours, think in terms of business days, one, because this is legal representation. That's generally the norms. Generally, these cases are not so urgent that though they're very important cases, they are not so urgent that we should be thinking in our timelines like this, given the nature of the practice. We think in business days, and then we look at some language that recognizes the reality that these are child clients.
Like Jen's language she put in the chat.
Right, all right, sue me.
Well, you might want to change 72 business days because that's a lot of months.
Yeah, I went to 3 business days. Again, writing it out helps me figure out where I'm wrong.
Yep. So I'll put this in a note too, and we can come back.
I like that a lot. That was great.
Yeah.
Jen.
And keep in mind that we're discussing the action, not necessarily I mean, at the moment, we'll come back and we'll go through these actions to see what, if anything, we want to make black letter.
Well, and so
But
my
sorry.
recollection is that part, as on mine, I indicated that should become part of the
Yes.
black letter. And Kevin,
I
am I
don't think
hearing?
I don't think anybody disagrees that we need a first contact provision.
Okay.
Yeah, I think that's, yeah. Okay, let's head to B.
Just in case it needed to be said, the preferred method of contact for the child is just because sometimes you get teenagers who just don't want to see you. They just want to text you when they need you and then ignore you every other time you want to get into contact with them.
Yeah,
Kevin?
I will say though that I'm not a huge fan of texting with clients, unless you have a work phone, which not everyone does.
Google
Kevin,
Voice, work number. You don't need a new phone. It's perfect.
Go ahead, Donna.
For process, do you want me, when I'm looking at mine, the parts of where I thought some action items or comments should become part of the black letter, do you want me to mention that as we go through, or should I hold off and discuss it when we go over the action items?
I'll hold off because I think what I want to do first is get through the bolded stuff, and then we'll come back and we'll do another pass for the actions and other things, actions and commentary. Okay. Child client's attorney should communicate with the client in a age and culturally appropriate manner. I put this as a best practice, not a black letter rule. I think it's hard to hold people to this contractually because the number of people who will have the knowledge to be able to do this is a smaller slice. It's a smaller universe than the number of people who are doing dependency work in general. And I think it's by a large margin.
And after you commented that, like, I originally was like, yes, this needs to happen. And then you made that comment. And then I realized, like, and are you going to like test people on it? Like, do you know this culture?
And honestly, one of the things I struggle with language like this is, what does it mean?
Yeah.
There is that too. Like, if we need to put these into performance like we have performance standards, that's what we're developing now. But if we need, like, OPDC wants to be able to monitor these and put them into performance metrics, how?
Yeah.
What is the metric? How do I measure how culturally appropriate an attorney is being? I don't know how we convert that.
I do.
Although I will say, like, the concept is that we'll have certain, like, performance metrics that might flag someone in our system as we need to go check and see boots on the ground how things are doing. Like, no one hopefully would ever just like get an automated letter saying, hey, you suck, without a human ever actually going to review something. So, like, yeah, that's kind of where I'm coming from, is this is not black letter. I don't think we can make it black letter, if that makes sense. Don, did you have, I thought you might have had a comment there.
I'm trying to get better at typing my comments. I support removing it.
I just noticed that you put that in. Thanks. All right, let me mark this as blue.
I think it definitely makes more sense to include it as like a, hey, when you're having contact ongoing, try to make sure that you educate yourself on things that are developmentally and culturally appropriate for that particular client.
Yeah. Yeah, I mean, and I think that applies to a whole host of the things, right? Like, when you're trying to determine a child's position on permanency, you kind of have to take into account, well, if it's a child of color and the adoptive family isn't, there are dynamics there that kind of need to be managed, because you're not looking at just like, what does this kid think they want right now, but you also have but this kid's also 3, and when they're 13, that's going to be a very, very different calculus for them. So, okay. C, the child client's lawyer should show respect and act professionally with the child client. I also think that this is largely a best practice. But I also think that act professionally is not always necessary at all, because some of the best fun you can have with a child client is having fun with a child client. And I don't know that that necessarily falls within the scope of acting professionally, right? I don't like the term here, but I'm not like wholly married to that, right? If other people think differently.
To me, this was all about the context.
Hmm.
To me, this rule is don't look schmoozey, like, like you're schmoozing with parents, attorneys, like, because you can ruin your relationship with your child client.
Yes.
If you show up in court and you're BFFs with all these people that they hate, or think, like, that's what this rule was looking at for me. Like, or that's what it was saying to me. But because I
think that
completely agree
action-
with you. I'm on trampolines like multiple times last week. Like, I don't know if that's professional or not, but that's what I'm doing.
That's true of every client and
Mhm.
not child client specific. And I'm wondering if that's not encompassed in the RPCs and that we don't need it because we should have a black letter standard that says you must comply with the RPCs.
Respected how they interact. Yeah, I like that, Jen. Child client's lawyer should treat the child and their opinions with respect in how they interact with the child and other parties involved in the case.
Because when I read it, it was more of like, don't treat them like a little kid. Don't belittle their opinions. Don't belittle their thoughts or what they want to have happen from the case just because they're 6.
Right.
Your job is to go and essentially treat them as a mini adult to the extent that they can function that way.
Yeah. Okay. I think we have consensus on that. Does everybody like Jen's language?
Yes.
Yeah.
Kelsey, I kind of read a comment on your face, but I'm not 100% sure.
I don't like the way that reads. It's just not flowing in my brain.
I can wordsmith it.
Yeah. I mean, if the words are right, there's just, yeah.
I agree. The sentiment is right. There's
Yep.
a little tweaking to the syntax or something that needs to go. Okay. Child client's lawyer must abide by confidentiality laws as well as ethical obligations and adhere. This is black letter. There's no, to me, there's nothing getting around this.
Mm-hmm.
All right. Oh, I colored that wrong. Thought that was going to be yellow.
I agree. It's important. And also, it hurts a little that we have to remind people of this. Like, these are still clients.
Yep. Okay. Child client's lawyer must avoid conflicts of interest and should avoid the appearance of conflict of interest. I put this as the first half as black letter. I'm not sure how to handle the back half because
yeah,
it's like, I don't know how we could, I don't know. When something isn't an actual conflict of interest, it gets really at the core, like it's with the relationship with the client, but it's maybe not an ethical issue.
Kevin, can you give us an example of what you deem would be an appearance of a conflict of interest for child case?
So the easy one to me is siblings, right? If you're representing multiple siblings on a case, it is easier for there to become an appearance of a conflict of interest, even if the siblings are actually all aligned, or if there's a way that you can represent each of them effectively. Until you have an actual conflict of interest, it's not an ethics issue, right? And once there is one, because the Oregon doesn't have potential conflicts, it just has actual conflicts. So you have to determine whether that exists or not. I think the part of the reason why I think the back half of this is more a best practice than it is a black letter rule is there are areas where there just aren't enough attorneys to represent. Like the best practice, court is assigning a different attorney to every single kid because at some point they might have conflicts of interest, right? But that's just practically unfeasible in probably 75 to 90% of the state, if not 100%, right? Like, I don't think the courts are going to be able to, on every case, assign a different attorney to every single kid. And so, like, to me, part of what this rule is getting at, like, because there is specifically the actions about sibling representation. It really is getting at, you've got to be real careful when you're dealing with siblings in the same case. Because as soon as one of them materializes a conflict, you might have to withdraw from everyone. And I know that a lot of attorneys operate by the rule of keep the kid who has capable of direction and drop the kid who like have somebody else take over representation of the one for whom you can use substitute judgment, because that kid you probably don't have secret information about, but maybe you do. Like, it all depends on what you consider to be secret information. So it's harder there. Yeah, Dawn.
What if we put something in there that directs the contracted lawyer to seek separate counsel when it appears that it is possible or highly possible or something like that for a conflict to develop if you are assigned to represent siblings? Because I had a case drag on so long and I had 3 little ones, and that's exactly what happened. I mean, like every couple months at a certain point, I was like rereading the ethics rules, trying to make sure that, and ultimately I ended up getting off.
And Jen, I like that idea too. I don't have a problem. I'll check and see if we're good to do that. I will say that ethics counsel is not always great about answering questions in dependency because they don't really know much about the underlying practice. So, okay, I will add that as a note, and we can work with that, and I'll see if that's a good thing. If that's something that we'll be able to put in. Okay. I do want to be mindful of the time. It is 6 o'clock, but if I'm not mistaken, we're pretty close to, well, we've got a bit further to go before we get to the, well, no, standard number 3 is just A. So we've only got a couple of things. Is everybody good to stay for just a few more minutes and we'll knock through F, G, and 3A?
Mm-hmm.
Okay, cool. All right, double checking. Yeah, okay. F, child client's lawyer should advocate for actions necessary to meet client's educational, health, cultural, and mental health needs.
If the child wants. No, I mean, I've had kids who, I'm like, do you want education advocacy? We've got this great person in my office. And they're like, nope.
I love the ones who you're like, I love the ones who you're like, do you want to go to therapy? Therapy's great. And they're like, absolutely not. I refuse to go to therapy. You're like, Your Honor, my client does not think therapy would be beneficial in this case.
What about changing it to say we should consult with our clients about the options and advocate for actions necessary to meet if the client directs us, or
I agree. I think, and that I've got the note here, subject to client direction. I can workshop the language
Yeah.
outside of the work group.
Oh.
Okay, but does everybody think that this is black letter? I mean, it seems kind of core to dependency. We're not talking about
Yes.
the collateral stuff here yet. We're talking about the stuff that's part of being taken care of as a child in DHS as a normal child. Yeah.
I think my note was to one of my notation, or in my brain, it was like, when we say advocate, we are not saying represent. We are saying
Right.
seek out their legal guardian is DHS, and we should go to them and say this service needs to be provided, and it is we are asking for you to
Yep.
do it, and then take
Yep.
further action.
Yeah,
Yeah,
because this also, to me, is like, I mean, there's plenty of services that DHS throws the kids in, but are they adequate? Like,
Yeah.
you know, are they actually doing what they need to be doing? And that's our job, is to make sure that they are.
All right, so I agree with all of that. Okay, so we've got that. I'll mark this as yellow. It is yellow. Good. Stay yellow. No, and it's blue. How did? I don't understand sometimes. All right. G, child client's lawyer should take appropriate actions on collateral issues. Worded as it is, I feel like it's black letter, but it's so vague as to be darn near meaningless. So my preference would be to workshop and wordsmith this and deal with it more as a, what do we mean by appropriate actions? And I don't think we can contractually obligate this.
Yeah.
That's the big pieces. I don't know how we do that. What do you guys think?
My big focus, Kevin, is the Constitution, the what is statutorily and mandatorily statutorily and constitutionally mandated for court-appointed attorney does not include an attorney for all these other things that the children that are not, and you're not going to be able to pay for it, right?
And like that is the other flip side of this, is that we can't fund a lot of this, right?
And
so
the more-
contractually obligating somebody to work pro bono feels a little Amendment 13-ish.
Well,
right?
and I think the problem is then our caseloads have to go so far, get so much lower, right?
Well, yeah.
The more
I mean,
you want, if you want me to provide legal services for things that 90% of children in this country do not get lawyers for.
Yep.
Then
I think a lot of this will be ideal, best practice. I do think that there is something that could be included. Specifically, I'm thinking of dependency and delinquency. So like if I'm contracted to represent, right, like OPDC is going to pay me to do both delinquency and dependency. How can I try and, how do I make sure that I can get on both of these cases? But I guess not all attorneys are going to take a delinquency dependency contract, are they?
So
Not
so the way that we theoretically contract is that an attorney can't, I mean, when I was there at UVPD, I didn't do any delinquency work, right? But partly that was because there were other attorneys who cornered that, you being one of them, right? Mm-hmm. So like, the way we contract does not distinguish between dependency and delinquency, with the exception of PCRP. Wait, no, not PCRP. Juvenile having a delinquency only funding level. So it is possible that some people opt into doing only one or the other, but it's not 100. Like that's not part of the model that we use.
But you get case credit. I mean, you're getting paid because you get, at least I'm a PCRP.
Mm-hmm.
Like and I'm certified to do it all.
Right.
So I'm getting paid because I get case credit. I get case credit for the delinquency case that comes in and the dependency case on child. So,
Right. Yeah.
but I think including something somewhere, if I read it all, we do require consultation with lawyers that are representing them if they're not. The lawyer that's handling the delinquency matter if they're not handling it. And we should include something that says we should require them to seek out seek out representation if there is going to be a delinquency case, because
Delinquency
you do
exposure.
pre-petition
Yeah.
work on those.
I was thinking about that too, Jen, about SIJS being a separate black letter. I think because what
So
I'm not.
Kevin,
Go
my
ahead.
comment was that I don't think it's collateral. Getting the findings is not a collateral issue because it can only be obtained in a child custody proceeding. And if there's a child custody proceeding, which is a dependency case,
Right.
you need to get those findings. It's my own bias because I do these cases, but I think calling that collateral is
So for
problematic.
you, it's more of a potentially and forgive me because this is not I'm not as familiar with this. So I know that we have the immigration referral program for criminal cases, but in your mind, that would be a consultation that should be done in any dependency case as well that implicates immigration issues. And
Well,
SIJS would implicate those.
So I think that because there's the state court part of SIJS, yes, I mean, I think you're going to have to do an immigration consult. Most people are going to have to do an immigration consult to know that SIJS is an issue. You can't, I mean, there isn't the same process through I'm always forgetting what they call themselves. The Oregon Justice Resource Center.
Oh, yeah.
For dependency. Okay. Yeah. So
I that is something that I would need. Okay.
So we can think about it.
Yeah, we'll think about it. Yep. Okay. And then I think the last one is 3A. Child client's lawyer must provide competent representation to a child client. It requires legal knowledge, skill, training, experience, thoroughness, and preparation reasonably necessary for the representation. Lawyer should only accept an appointment or retainer. The lawyer is able to provide quality representation and diligent advocacy. Dawn, I know your comment was basically, isn't this just the qualification standards? Like making sure you meet qualification standards. Okay, cool, Dawn. So I don't disagree with you, but I don't think it hurts for us to include that in the document. Because the qualification standards refer to you must agree to abide by the performance standards. I think there's no problem in my mind of having the performance standards be, yeah, also you have to be qualified. I think that makes sense for both of them to reference each other.
So this might need some wordsmithing, and it might just be because I'm going to say this with a lot of air quotes, a young woman. But when I read this, I immediately hit that imposter syndrome point,
Mhm.
and it makes me feel like I should not accept any court appointments for dependency because there's just so much within it that's like you need to know, be competent in all of these different areas. And I think we all know when we're practicing, we all come up against areas that we just don't know. And you don't know that at the start of a case. And the bigger point is knowing how to reach out for advice and help and expertise on those issues. So I just a heads up that maybe in the way that we word this eventually to create something that doesn't just have that knee-jerk reaction of, oh, you're not good enough to do this.
It turned blue again. Why does it keep doing that? Okay.
Your
Okay.
highlighter pen is set at blue.
I guess. Excuse me. And I would agree, Jennifer, I was not going to repeat the qualification standards here. No, the documents can reference each other. They don't have to incorporate each other, because then you just get into like a standard section, because every time it comes up in the other one, you have to then reincorporate it. Yeah. Okay.
I did laugh at the idea of visiting to child or adolescent psych wards as on page 20, that you should do these things, because I'm like, you can't get in them if you don't have a client there.
Also, can you find some with enough staff and time to give you a tour of them?
I gotta tell you, many of the ones that I went to was only because I had a client there, right? I didn't visit them before I had a client there.
I'm not being rude. I have to let my family know I'm running the meetings going long.
It's okay. I think we're about to wrap up too. Yeah. Jen, I take your point. I take your point pretty heavily here. I also agree that we need something in here to make it clear that it may not necessarily be individually, but ensuring that you have the support, like the practice support network to help get you to the quality representation. It is important, because I do agree that none of us can do this job on our own. That there's far more involved than any single person is likely going to be able to do without.
And DHS
Yeah.
is constantly changing the rules. I just had a case today where they're like, oh, and by the way, the current caretaker status no longer applies to permanent guardianships. And you're like, I'm sorry, what? Anyways.
Is that like a change, or did they just finally realize something? I mean, I think the current caretaker status, they frequently misunderstand, because I'm pretty sure it says that they have to have had a relationship before, or maybe I'm thinking of something different.
You might be thinking of something different. It's the 12, so it's when a kiddo has been there for 12 months. But they usually apply it when they're looking at permanency planning for adoptions, permanent guardianships, etc. Well, the relative pathways program that they're piloting in Washington County is changing that to be so it's only considered in adoptions. And that any relative, even if they show up 2 years into the case and have never had a relationship with the child, will be prioritized over a resource parent who has had 12 months with the child. So it's a current pet peeve and a fight of mine that I'm having, but it's an issue that I don't think anyone would be competent in, because it wasn't an issue until now. So
Gotcha. Okay.
Yeah, they just make shit up. They just make shit up.
There is that too. Dawn, did you have specific language?
No, but I think I think what was just defined about, like, I think the language would include recognizing that seeking out further consultation for other lawyers when you don't know an area would equal quality representation and diligent advocacy. And I've got the recording thing's blocking some of my pictures, so I can't see who's talking a couple times. But I can't remember if it was Kelsey or Jen that said that, but she said, like, what she described she was doing sounded like competent representation to me. So I don't know. Occasionally definitions could be helpful.
That's a thought. I don't know that this document is necessarily going to need definitions like that. Whereas we could probably just like define the thing when we're talking about it as part of like a narrative. Anyway. Okay. We've gotten through at least the bare bones of the homework. there is still a lot more to do here because we didn't even really talk about the actions and commentary. But at the very least, we've got bones here and we can work with them. Awesome. So if I'm remembering right, our next one isn't for 3 weeks. Is that right? Yeah, oh, 4? No, hold on. No, it's 2 weeks. It's the 8th. It's the one Tuesday that we have. So 2 weeks. How do people feel about getting through? Let's flip through a full page. Standards 4, 5, 6, and 7.
How many
So-
pages is that?
7 gets you through to page 39. So approximately 20.
I could do that. Do you want us, Kevin, is it just helpful not to worry about the comments now and just focus on the black letter and this similar to the system that we used? And then,
Sure.
okay.
I mean, as I'm going through, I'm going to be marking the entire document in colors, just because that's how my mind works. And
Yeah.
then we could pull some other stuff in later. But I think what we'll do early is just try and get, and then if we have time during some of the sessions, and I imagine that a lot of the parent stuff is going to go faster because we've done the same analysis on the child stuff. All right. Before we break, any questions or comments or anything?
Can you either throw in the chat or send us a quick email telling us what you just said about the standards you want us to get done?
Sure can. I'll throw it in the chat because it's easy. I'll put it in email because there's a lot of folk who aren't on this. But yeah, I'll just do it in email. All right. I will
everybody.
probably send that out in the morning because it's late.
Thank you. Take care, everybody.
Bye.
Have a great night, everybody.
Bye.